Today we're going to be talking about patents, U.S. patents versus U.S. foreign patents. My name is Jason Wachter. I'm a shareholder at Gottlieb Bracken Reason. My contact information is on this screen below. You need to reach me. Feel free to reach out with any other questions after the presentation. Unfortunately, there's a lot to cover, so I'm definitely not going to be able to get through cover every aspect of the nuances between U.S. and foreign patents, but I'm happy to continue the conversation afterwards. So hopefully I could touch at least on the high points during this discussion. So for those who are unfamiliar with patents, and I apologize for those that are on here that do, but I want to make sure that everyone's on the same page. There's three different type of patents essentially that you can obtain. One is a utility patent, one is a design patent, and one is a plant patent. Today, we're not going to talk about plant patents, but I wanted to just acknowledge them. And for utility patents, there's multiple types as listed here. You can file a provisional patent, a non-provisional patent, or an international patent application commonly known as a PCT. And for designs, typically, you can file a national stage, or if you wanted to file a larger application, you can file an international application that covers multiple countries. There we go. So to get into a little detail on the patents, I wanted to just provide a little background before we got into the differences. For provisional patents, for those that don't know, this is a great way if you want to get a patent filed quickly because you're going to launch a product or potentially show it at a trade show. I know that's not common these days, but or talk to an investor, or just also want to save money. It's a great way to get a placeholder at the patent office. They're not examined and they last about a year. So it's both an economical tool and also a good way to get at least your foot in the door at the patent office. Yeah, within a year, you have an opportunity to claim priority the provisional patent application and convert it to a non-provisional application that would be examined by the patent office. But the benefit of the provisional is you get the earlier filing date of the provisional as your date of patent filing. So essentially, if anyone came in after you filed your provisional application, you would be first in line at the patent office before them. And a non-provisional application, as I mentioned, gets examined. It's much more formal than a provisional. You have to draft patent claims. Figures typically have to be in formal looking figures, although it's subjected to the patent office. There's also a lot of sections that have to be added, which is background and specification, detailed description that are not necessarily required for provisional filing. For a PCT application, it's very similar to a non-provisional application. The benefit there is that it opens the possibility if someone wants to seek protection outside of the US within 30 months from the earliest filing date. So if you have an interest in filing in Europe or China or Canada, and you know this is down the road, you would want to file a PCT application at some point. And also it helps if you don't want to spend all the money in every direct country right away, you could spread out your filing so you don't have to wait 30 months. You could say file in China sooner rather than later, or Europe or elsewhere, Mexico, Korea. And that way it preserves your rights to file in multiple countries at a later date. So that's pretty much a general outline of the utility patent system. For design patents, the difference here is that you're protecting the ornamental look of a product, an object, the surface, an article of manufacture, essentially. So you're not protecting any of the functionality at all per se, you're just protecting how it looks on the surface. And here's some examples of design patents I wanted to show you to give you an idea for those who don't know. There's different ways. So for example, one of our clients we represent is Longchamp. They make handbags and other things. There's a patent on the left there of a handbag you can see. So that would be one way to protect the handbag because the functionality is not there unless there's something going on, but you'd want to still protect it. For example, there's Ferrari had filed one on various body panels for their car and the overall look of one of their vehicles. So if they wanted to, I'm sure they have underlying utility patent protection as well for various aspects of that car, but just the look of it, they filed for patent protection as well. I think we have two more, right? And then here's another one. We have one of our other clients, Contemporary Vision. They are in the lighting industry, and then there's a picture of an aspect of a sneaker that Nike has. And the reason I wanted to highlight these two is here's one difference between the U.S. and some regions. Here, there's aspects of these patents that are shown in dashed or dotted lines, that means that those features are disclaimed in the US from the design, so it attempts to broaden the scope of patent protection. For example, in the lighting one on the left, what you're claiming is just a section of essentially a board where the light is sitting on in one light fixture. You're not having to claim specifically all three in the very specific detailing of the actual light fixture. The difference, in the same thing with the Nike shoe, they're just claiming the upper portion of the sneaker. They're not claiming the sole. However, in certain regions such as China, this is not possible. You have to claim the whole product. You can't use dashed lines. So this could become problematic if you're not prepared for that down the road. You want to make sure that if you're filing in certain regions such as China where this is not permitted, that you either work with local counsel or you work with a draftsman to make sure that the drawings are converted correctly so that you don't have issues in terms of registration in regions such as China. And that goes to also the Hague, where one benefit of the Hague is you can file in multiple countries. One negative is if you are preparing a patent application that maybe is permissible in one region, it might not be permissible in another, and the ability to modify the application at a later date in some instances, depending on the situation, may not be possible, and you may have to refile an application directly in that country. So for that, while there are benefits for a generic filing that would give you potential protection in multiple regions, there are drawbacks to it too. So I would caution before anyone uses that you'd have to look at specific situations before you decided to go that route. You should also know that, and I think it will say in the next slide, that there is, Kendall, why don't we flip to the next slide? I can show you that. Right. So the timing to file applications. So this is again difference between the U.S. and elsewhere. The U.S. and some other jurisdictions for utility patents, from the date of public disclosure being on sale, essentially any kind of disclosure whatsoever, you have 1 year to file a utility or design patent application. Now, public disclosure, it's a little gray in the courts is what that means. Some people say it could be, even so much as discussions that weren't truly quote unquote public. So to be safe, you want to make sure that you get a patent application on file within 1 year. And also, this is where the provisional application might come in for utility patents. Before you have those meetings or discussions outside of your company, it might be good just to file a provisional patent application so you don't have to worry about what date the things occurred on. And also you don't have to worry about, you also have a little bit of comfort in knowing that you filed a patent application and you're disclosing something, even if you're filing even if you're disclosing under an NDA, that you have a little comfort in knowing you filed an application for it. For designs, you also have 1 year. However, I would caution that in some jurisdictions, for utility patent filings, for example, in Europe in particular, and China, we run into this a lot with our clients where they've gone and said, oh, we have this product on sale for 3 months. We want to file a utility patent in the US, and we make it in China, and we want to file an application in China, and we're going to sell in Europe and Canada and elsewhere. That's great, except there's certain regions that, depending on the situation, and many times, unfortunately, it's the case, if you started to sell your product or you're publicly disclosing it and shipping it, there's an absolute bar in certain regions such as Europe and China that you have to file a patent application before public disclosure. So while the 1 year applies in the US, it doesn't in other jurisdictions. Now this is even becomes a little more nuanced in, in Europe, where utility patents is not permitted, but for design applications it is. So you can publicly disclose and then within 1 year file a design application in Europe. That's not the case in China. There are other regions that have other nuances as well that I'm happy to talk about offline, but the moral of the story is that you want to make sure before you disclose anything publicly, irrespective of what jurisdiction you're filing in or what you plan to do, you really want to talk to a patent attorney in your region, because you want to make sure that you're able to acquire patent protection if that's what you want. The last thing you want to do is put yourself in a position where a competitor might come out there and try to copy your product or be in the same space, and you're missing out on potentially protecting your product or design because you didn't, I guess, meet the requirements of a specific jurisdiction. And again, this kind of goes to claiming priority. So for, I'll go kind of in reverse here. For designs, if you filed an application in the US first, you can file, you don't necessarily have to, you have 6 months from the date of filing in the US to claim priority to your earlier US filing date in most countries around the world. So if you wanted to file in Canada, in Korea or Australia, you can file within 6 months and you'll get the US filing date on that. The utility patents, again, you have 1 year to file directly outside of the US or within a PCT. For PCTs, what I mean by 30 months from the earliest filing date is that if you file a provisional patent application, that can be considered an earlier filing date. If you had a foreign, earlier foreign filed patent somewhere around the world, that could be an earlier filing date. So you want to talk to, counsel like us, make sure that if you are close to that 30-month deadline, you're not beyond it. There are also some nuances to that in some countries, for example, Europe, and there's a little bit of a mailing period in China, where there's certain things where there's filing periods where they're slightly extended or extendable beyond the timing deadline. But I wouldn't, unless it's an absolute, we do have clients that it runs into it for various reasons, and it works out, but other times it doesn't. I wouldn't want to try to butt up against the filing deadline if you can avoid it, because it's not beneficial, especially also if we're trying to work with foreign counsel and they're supposed to file a patent application for you by a certain deadline. The last thing you want to do is say, the day before the day it's due, by the way, you need to file this today, because it's human nature, errors can happen, and we want to make sure that we give people a courtesy of as much time as possible to prepare and address open issues that may result. So I would just say to try to get your clients, if possible, to give you at least a little bit of lead time before they want to do things, because you want to make sure that you're doing the utmost best job for the client. And like I said, if issues arise, at least you can discuss them before proceeding. So for design applications, here are some other differences that I want to touch upon between the US and outside the US. In the US, in most regions, where you're doing line drawings, typically 7 standard views are what's customary. And what I mean by that is there's a perspective or isometric view. You're viewing it from the front and the back, top, bottom, left, and right. Other regions, when you do community design, such as in Europe, a lot of times, if they're direct from Europe, there would be photographs of the products, like you saw the handbag here, and those could be used in the US as well. But typically in the US, photographs are frowned upon unless there's a specific reason to start, as are color images, unless there's a specific reason to use color in your design. And the USPTO in particular is one of the main things they look at in design patents is making sure that the lines are drawn properly, they're consistent amongst the views are consistent amongst each other. The easiest way to get a patent application is rejected is if the drawings are not consistent amongst themselves within the patent application. So you want to make sure before you put an application on file that all the views are consistent with each other, that if you're disclaiming features, they're disclaimed consistently through all views. If you're showing a certain shading, the shading is the same where shown in all views. That could be problematic. Now, again, in certain foreign jurisdictions, as I pointed out, photographs are not permitted. Also, as I pointed out earlier, such as in China, disclaiming features is not permitted. So you want to make sure that you're complying with local jurisdictions and working with local counsel to make sure that you're complying with all the rules. The other thing that I will say is that in Europe and now in the UK, which is more recent with the exit of Brexit, you're allowed to combine multiple related applications of quote unquote families into one patent application, or possibly 2, depending on the number of views and applications. So that's a cost savings in those regions where, if, for example, you have a bunch of lighting products that are related, or a bunch of handbags that are related, or jewelry products, you can put those in a single, or hopefully less than, say in the US, you file 5 applications, you might be able to file 1 or 2 in Europe. And that can be a cost savings to a client, and you still are obviously obtaining the same protection you would have whether they were filed in 1 or 5. That's not allowed in other regions like Canada or the US, but it's good to know and speak with local counsel to see if there's a way to combine the applications if possible. So I wanted to point that So the difference in between jurisdictions. So for the USPTO requires examination at the time the patent application is filed. And this goes for both utility and design applications. You have to make a request and pay money for examination. Now, that doesn't mean examination happens right away. Unless you file for expedited examination, which you pay extra money, that you typically are not going to see an application examined for well over a year, probably a year and a half to 2 years. With COVID, it's been a little longer. But if you do have a client who wants to get a patent application examined quickly because they really want to try to obtain a patent quicker, then what you could do is you request expedited examination. This is required at the date of filing. Essentially what it is it's a request form filed with the USPTO, and you have to, you'll get it for the utility patents. You file a request at the time of filing, and typically we're seeing examination within 3 to 5 months from the date of filing. So if all goes well, you could potentially have a patent with under a year. For design patents, there's a little bit more of a requirement. Here, you need to conduct a thorough search and file an IDS, an information disclosure statement outlining all the search results with the patent at the time of filing. So you have to have a outside search done to essentially assist the USPTO with their duties. In addition to filing a request, it's a little bit more money because you also have to do your own searching in addition to their searching. That's one way to help it. That being said, in terms of the examination and search fees, I know, for example, there's regions in China, Europe in particular, and others that you don't have to request examination, and also in Canada for certain filings as well. At the time of filing, you could wait until a later date. In fact, you wait quite a while. In some instances, it's preferred or not even allowed. So it's one of these things where you want to, again, speak to your clients, speak to local counsel, figure out what the client strategy is, figure out what can be done locally, what makes sense outside the US. But in the US, you don't really have a choice in terms of examination, but you should know for your clients or for just clients that are on here that if you want in the US in particular to try to get a patent sooner rather than later, there are mechanisms to do so, but they're not inexpensive. So for maintenance fees and annuities, the difference here between the US and outside the US is with design patents, there's absolutely no maintenance fees. You essentially pay an issue fee, once you get a notice of allowance, and the patents expire 15 years from the date of issuance for any patent application that's filed after May 13th of 2015, or if it was before that, then you get a patent for 14 years. For utility patents, once you pay the notice of allowance issue fee, you have a utility patent in the US. However, in order to continue to own, I guess you could say, utility patent, you have to pay a maintenance fee every 3.5, 7.5, and 11.5 years, meaning that you have to pay the government, the USPTO, money to keep your patent. And the fees do escalate in cost over time because they presume that you are using the patent and monetizing it. And that's why that's the case, regardless of whether you're an individual or a Fortune 500 company. Outside the US, many, almost all regions require annual annuity fees. These are due even if the patent application is pending. It doesn't matter whether the issued or pending. You still have fees that are due on an annual basis to keep things going. So you want to also make sure that typically, I know us, we work with great foreign associates outside the US who notify us well in advance so that we can provide our clients time to consider what they want to do. But it's important that you meet these deadlines because the last thing you want to do is have a patent application that goes abandoned for not paying fees. I will say this, going back to the US in particular, that while those deadlines, the utility patents are there every couple of years, they are extendable for a short period of time. So there's a window to pay those fees. But, again, it's not a significant window, but it's got to be nonetheless, if you want to maintain a patent application, it's a utility patent application in the US, you have to pay the government money. So I wanted to touch upon one last thing here. This is the patent prosecution highway for utility patents, and I'm not sure, on here who's familiar with that or not. Essentially, what this does is that it speeds up examination for applications that are for select, patent offices around the world that are working with the U.S. Patent Office. So if you were able to get at least one claim allowed in the U.S., granted a patent application, you can use that allowance to try to get a quote unquote fast track application, say in Europe, for the same one. What this means is that the examination is leveraged from the U.S. in Europe so that the examiner in Europe now has all of the details of what happened in the U.S. And typically, from what we've seen, this works to the client's advantage because if you have a patent application that was allowed within a certain period of time in the U.S. and hasn't been examined in a foreign region yet, you leverage that, and typically it makes it much easier to obtain a patent quicker in that region. The opposite is true as well. If you have one of the participating countries in this program that you're granted a patenting, and you have a pending U.S. application that hasn't been examined, a lot of times that's also helps out in terms of expediting the examination in the U.S. and allowance. However, if the application was examined in the U.S. and then it was examined in, say, with Canada, you can't then try to use this program because the examination process is already in place in both regions. So that's one thing to keep in mind. And I think that's pretty much it. I know that there's a lot more stuff that we could cover in this, but I wanted to keep it kind of top level and figured we could discuss some questions if anyone has any. And if not, like I said, I'm happy to talk offline.